recording available of the webinar for anybody who you want to share it with after the fact. If you ask us about it, we'll probably send the link out to everyone, but if you ask about it, we can get you a recording. I do want to encourage people to ask questions as we go along, so please type your questions in the chat box, and between Elizabeth and I, we will see to it that we get to all the questions. Here's what we're going to do. For about an hour, we're going to talk about how the ABLE Act can work in Arizona right now. And let me just go ahead and do some spoiler alerts and tell you that you can open an ABLE Act account in Arizona right now today. There's not any requirement that you wait for the Arizona legislature to do anything. There's not any requirement that Arizona's Medicaid program adopt any rules or regulations. The ABLE Act is available in Arizona today. And if you have a case or you are involved yourself in a circumstance where an ABLE Act account might be a suitable choice, we're going to tell you that there are a couple of different places where you can get an ABLE Act account opened up today. In fact, there are 4 states that have accounts open and available. There are 5 states that have them. Florida is restricting its participants to only Florida residents. So here on this slide, you have the information about the 4 available accounts and some of the ground rules of them. They're in Ohio, Nebraska, Tennessee, and Michigan. Ohio's ABLE accounts are, they have a $50 minimum deposit. They charge about $60 a year in fees. They have a stable, they call it, debit card that is keyed to the account. That looks like a pretty good choice for most of the kinds of uses that we think people are going to find for the ABLE Act. And we predict that that's probably the state that will see the most new deposits until some other state develops an even better program, if that happens. Nebraska's program has been running for some months now. They also have a $50 minimum opening account balance and also a $25 per deposit minimum addition to the account. Their fees are slightly lower, $45 a year. They're very clear that their investment costs come off the account as well. So there are some management fees for the investment options that they have. They're very modest annual fees, however, and so that shouldn't be a big issue. They're on the order of 0.3% for most of the investment choices. Tennessee's program is free, sort of, the only charge is the 0 to 0.3% or thereabouts annual fee that they charge depending on the kind of investment it is, that is really looks sort of like an investment cost. I will say that Tennessee's disclosure statement is 40-some pages long and impenetrable, and I wonder who they think they're marketing it to, but if you can wade through the whole thing, you'll find that the costs are extremely modest. The number of choices, I think, are a little bit more restricted in Tennessee than some of the others, and the flexibility of the accounts are not quite as impressive. Michigan is the 4th, or really the 5th state, because as I say, Florida has had ABLE Act accounts as well, but just only for Florida residents. So Michigan is the 4th state available to Arizona residents. It's brand new, however. It just came online last week, and it's still not really available on their website. They don't really have very much information. You can download the forms and you can make a deposit, and I believe you can open an account today, but they're very much on the threshold of getting this going. So don't be surprised if Michigan takes a little longer, because their website really isn't fully populated yet with all the information. I can't tell you as much about the fees or the structure. So those are the spoiler alerts. You can open an ABLE Act account if you're an Arizona resident today. You just have to choose which of the 4 available states most fits your needs. I'm betting that probably Ohio, maybe Nebraska will be your answer once you look at them. If you're going to use the ABLE account the way that I predict you're going to use it, it may turn out to be that your circumstances are different and my predictions are inaccurate. Let's talk about a little bit more background and information about the ABLE Act and what it is and what the rules are and what's in the near future for changes in ABLE. ABLE is the Achieving a Better Life Experience Act of 2014. It's a federal law. It was adopted by Congress right at the very end of 2014 in December, and it immediately became effective in every state. There's a lot of conversation about whether states have to adopt some enacting legislation, and they do if they want to offer ABLE Act accounts through the state. The federal law didn't create the accounts or the structure for the accounts. It just permitted states to open them up. States don't have to create an ABLE Act account, but pretty much every state is likely eventually to get on board and have some sort of ABLE Act account available, including Arizona. What the ABLE Act did in 2014 was to add a new section of the Internal Revenue Code. It's not a new section of the Medicaid law or the Social Security law. It's a tax provision. It's intended to look sort of like 529 education accounts. You might be familiar with how they work, that parents and grandparents can contribute money to an account for the education of their children. That money can grow until the child reaches college age and uses the money to pay for college. It can grow tax-free, and when the money comes out for college payments, then the distributions are tax-free. So it's very much a tax law that's designed to encourage people to save for their children and grandchildren's education. People who had children with disabilities complained that they didn't have a comparable kind of avenue for saving for their children's future. And that was the genesis behind the ABLE Act account. This Section 529A was to offer something that sort of looked like the 529 accounts. As it turned out, it doesn't look very much like 529 accounts. But there are some similarities, and some of the logic comes from there as well. But that also means that the whole thing is controlled not by the social service folks, not by Social Security and Medicaid, but by the IRS, by the tax folks. And they use tax kind of logic and tax language in interpreting it. That also means there are some tax benefits for the 529 accounts, 529A accounts, the ABLE Act accounts, but I wouldn't put too much emphasis on that if I were you talking about it in the community, because the reality is the tax benefits are pretty ephemeral for a population of people that doesn't pay any taxes anyway. So you don't really think of ABLE Act accounts as great tax programs. You think of them as tools that can be used to improve the quality of life for people with disabilities. The original ABLE Act, and this is one of the reasons why there's confusion about state action, the original ABLE Act required each participant to sign up for an account offered by their own state, so that if Arizona never got around to offering an ABLE account, then Arizona residents wouldn't be able to sign up for any kind of ABLE account. In 2015, very quietly, Congress amended the law to eliminate the residency requirement. And that's why I'm so eager to let everybody know that you can open an Arizona resident can open an ABLE account right now today, because there is no residency requirement. There's no requirement that Arizona adopt any enabling law in order to allow Arizona residents to participate. And as I said a moment ago, there are now 5 states that are open for business with ABLE accounts: Ohio, Nebraska, Tennessee, Michigan, and Florida, although Florida's accounts are only for Florida residents. There are also some other things in the works. There is a consistent rumor that there will be a dozen or more states that will come together with one big consortium and offer a very good ABLE account using the combined power of the states. We haven't really seen what states those are or how that's going to look or whether it's going to be better than the existing programs, but that's sort of promising. One of the problems with the ABLE Act in implementation is that any one state is not likely to have enough participants to really drive a very effective or commercially attractive program. And so if there was a consortium, that might solve that problem. We don't know exactly how that's looking. At least Ohio has already said that they would be happy to rebrand their program. So if Arizona or some other state wanted to simply sign up with Ohio's, and the law specifically permits this, if they want to sign up with Ohio, then Arizona or New Mexico or any other state could have an Arizona ABLE account that is really just the Ohio account with an Arizona logo on it. So that may be the way that things go. Who knows exactly how they will look. There are several things that have been talked about in the ABLE account blogosphere and in Congress that haven't yet happened. One of them, three of them actually, have been filed with Congress and have had some consideration, and it looked like they might have some legs. They might get adopted to some degree at least. One of them was that one choice was that you would be able to put employment earnings up to the federal poverty level, which would be another $11,000 in 2016, into your ABLE account without having any effect on the $14,000 limit that we're going to talk about in a minute. That hasn't been adopted. It could happen. Another was to permit no consequence transfers from education accounts into ABLE Act accounts, so that if you had set up a 529 account for your newborn child and the child turned out to have a disability, that you could just move the money over without any penalty. That hasn't happened yet, but it may happen. It could even happen. Any of or all of these three could happen in the lame duck session in Congress before the new administration. If they don't happen, then they'll have to be reintroduced and rediscussed in the next Congress if they're going to go anywhere. The third change that has been proposed is probably the biggest one, as we'll talk about in a minute. Right now, in order to have an ABLE Act account, you have to be disabled, and your disability onset has to be before age 26. One of the changes would be to increase that age to age 46, so that an additional 20 years of disabling condition onsets would be eligible for ABLE Act accounts. That is probably the biggest change. That's the one that the advocacy community has focused on. They've said, unless we can get that change, we're not as interested in the other two. And so it may be that while Congress tries to figure out how much that would cost the government and how to pay for it, all of the other changes are put on hold. For the moment, though, the ABLE Act rules are all the same in every state because they're all federal rules. So here are some of the key concepts to understand. The first one is really big. It really controls a lot of the rest of the ABLE Act thinking, is that, and this is partly because the rules are being written by the IRS, not by Medicaid or Social Security. The ABLE Act accounts are owned by the beneficiary of the account. If you set up a 529 education account for your daughter or your grandson, you own the account, and so long as they're the beneficiary and the money comes out for their education, you and they get the tax benefits. You can change the beneficiary, though. You could say, oh, my granddaughter is not going to go to college after all, so I'll just change and make my grandson the beneficiary of this account. ABLE Act accounts are not like that. Conceptually, the ABLE Act accounts belong to the beneficiary and can't be moved by somebody else. They can't even be set up by somebody else, except that there are some short list. There's a short list of people who can open up the accounts for a person with a disability. But I can't just decide to open up an ABLE Act account for your disabled daughter because I like her a lot and I want to benefit her. She can do it. You can do it. Her guardian can do it. Her agent on a power of attorney can do it. But a non-parent, non-family member can't just open up an ABLE Act account. And as I say, that's going to turn out to be key to understanding the effect of a lot of these rules. The second important rule or concept to understand is that there's a maximum contribution level per year from all sources. So you probably know that if you want to make gifts to somebody else, you can give them up to $14,000 in a year without having any gift tax consequences. And that number is the same number for the ability to contribute to an ABLE Act account. The $14,000 limit for gift tax exclusion principles is the same number as the maximum ABLE Act contribution in a given year, but with this difference. All of the ABLE Act contributions from all sources, doesn't matter who, whether they're the beneficiary themselves, parents, concerned relatives, people in the community, all of those contributions totaled can't exceed $14,000 in a year. So if you put $10,000 into an account for your child with a disability, that limits their ability to add to it to no more than $4,000 in that year. Of course, the next year they can put $14,000 more in. If you put $100 in and now your mother wants to leave a lot of money to your child, well, they can't put more than $13,900 in that account. So maximum contribution from everybody in a year, $14,000. The accounts could earn interest or income. And if they do earn income, that doesn't eat into the $14,000 limit. That's just how much can be contributed to the account. The second rule about maximum size is that if the account grows to more than $100,000, and understand this is not more than $100,000 contributed to it, it's if the account grows to $100,000 or more, the beneficiary loses their SSI so long as the account stays above $100,000. Of course, you can solve that problem by spending some of the money and bringing it down below $100,000. That effectively means that the asset cap for an ABLE Act recipient beneficiary is $102,000 because, you know, they can only have $2,000 for SSI purposes, but up to $100,000 is ignored in their ABLE Act account. How are they going to get to $100,000? Well, it's going to take years to do it unless they have some fantastic investment choice in one of the ABLE accounts. But at $14,000 a year plus modest earnings, it's going to take 7 years or 8 years or something like that to get to $100,000. And by that time, who knows what the program rules are going to look like. But at least for the moment, the answer is at $100,000, you lose SSI. Importantly, you don't lose Medicaid at $100,000. The state must continue to cover the former SSI recipients' Medicaid, even though they've lost their SSI because they've gone over the $100,000 figure. The third limit with ABLE Act accounts is the maximum amount that can ever be contributed. And now we're back to contributions, not the size of the account. So no matter where the money comes from, any contribution over the life of the ABLE Act beneficiary can't total more than the state's maximum 529 number. That's the state where the account is, not the state where the person lives. And so it depends on whether you're looking at an Ohio or a Tennessee or a Nebraska or eventually an Arizona account. Arizona's 529 number is $426,000, I think it is. And that's a pretty typical number for other states as well. I didn't bother to look up Ohio and Tennessee and Nebraska because it seems to me that we're not going to have to worry about $400,000 limits for a lot of years, and by that time, who knows what the rules will be. So that's a pretty theoretical limit. It doesn't prevent the account from growing beyond $400,000. Of course, if you put $400,000 of contributions in and it grew by another, I don't know, $50,000 or $100,000, they would still be, the beneficiary would still be eligible for Medicaid, but they wouldn't get SSI because they would have been over that $100,000 limit. The next important concept that is very restrictive about the ABLE Act account rules is that you have to have had onset of disability before age 26. So if you are disabled as a result of an auto injury that happened when you were 28, an ABLE Act account is simply not an available option for you. But if you have the disability onset before 26, it doesn't matter when the contributions are made. You can be 60 years old and have contributions to your ABLE Act account so long as you were disabled before age 26. And that's true right now today. That if you wanted to make a contribution to an ABLE Act account for a person who had a disability and who was age 60, today you would just have to be able to show that they were disabled back before whatever 60 minus 26 would be years ago.
Robert, this is Elizabeth, and I'm just wondering, can you talk a little bit about who is going to actually be checking about whether or not the disability qualifies, and the timing of when the disability was actually, I guess, diagnosed?
Yeah, that's a really good question, Elizabeth. Thanks. So the law says you can prove that disability before age 26 any one of three ways. If you were receiving SSI before age 26, that proves it. If you were receiving SSD benefits, disability benefits under Social Security, your own account or somebody else's account, that proves you were disabled before age 26 if you were receiving those benefits before age 26. And the third way you prove it is by an affidavit signed by a parent or somebody who knows your circumstances. This is actually more profound than it looks like. If you go on, for instance, the Ohio ABLE Act account website, I've done this, and it asks, one of the questions as you're opening up the account, was your beneficiary, or you, if you're opening it yourself, were you disabled before age 26? You say yes. And then it says, were you receiving SSI? Were you receiving SSD? Or the third box to check is, can you get an affidavit that says you were disabled? And if you check that box, it will let you open the account, and there doesn't appear to be any further checking on it. Now, I'm not encouraging anybody to try to get away with something. Of course, you have to actually have been disabled before age 26, but the level of proof requirement is simply not very high, at least not so far. And that's probably a function of the fact that, again, it's important to note that this program is effectively being run by the IRS and not by the Social Security Administration. If the Social Security Administration was in charge, we know actually they submitted some proposed rules that would have a lot of double checking. We know that there would be double checking to a much more extreme degree than the IRS is asking for. So for the moment at least, you just have to assert, at least in Ohio, you just have to assert that you would be able to prove that you were disabled before age 26. The last concept that I want to talk about the ABLE Act accounts before we start talking about exactly how they work is the payback. A lot of the advocacy community sort of glosses over the payback, and it's not a small issue. If you have an ABLE Act account in your name, on your death, the state is entitled to just reach into the account and take back to the extent that they have paid for Medicaid. You don't have to pay back Social Security or SSI, but you do have to pay back Medicaid with all of the contributions, whether it's your money, your parents' money, your community contributions, it doesn't matter. So I don't think the ABLE Act account, for this and other reasons, I don't think the ABLE Act account is a good substitute for a special needs trust, particularly not the special needs trust that you might set up for your child with a disability to receive their inheritance. This is not where you want to put your earnings, your money, for the benefit of your child with a disability. However, modest amounts going into an ABLE Act account, and they have to be modest because there's a $14,000 limit. Modest amounts going in and actually being used are going to make a lot of sense in individual circumstances, as we'll talk about in a minute. So keep all of those concepts in mind about how you start the ABLE Act account and whether you qualify. But now let's look at some of the regulations and rules governing the ABLE Act and how it's actually going to be administered. Now, although I've said this is really an IRS program, and it is, there are some Social Security rules that impact how you're going to be able to use an ABLE Act account. But the good news is those rules have completely capitulated and allowed the very most liberal, best understanding of ABLE Act possible, pretty much, with one exception that we'll talk about. But other than that, these rules are very generous. So I have to explain a little bit for people who don't know about the POMS. The POMS is the Program Operations Manual System. It's an online resource that explains to Social Security eligibility workers how to interpret things, how to decide whether somebody is covered by Social Security or SSI, and they're incredibly detailed. There's a relatively new POMS section adopted in March of this year that addresses the ABLE Act and how it's to be interpreted. And in order to understand that POMS provision, and by the way, you should have the outline, the materials that I'm showing here in an email from me, and they should also be available as you're online watching this. You should be able to download the PowerPoint file, and the links should work. They should take you to the POMS section that's highlighted there. In order to understand what that POMS section means, you have to understand a little bit about in-kind support and maintenance. So I'm not going to give you a full tutorial on how it works. Just understand this. If you are a recipient of SSI and somebody hands you $50, you're supposed to report it, and it'll reduce your SSI by $50. That's not quite correct, but let's be simple about this and say it'll reduce your SSI dollar for dollar. If they hand you the $50 and say, here, use this to buy food, and you do in fact buy food, still there's a $50 reduction. If they hand you a gift card that could be used to buy food, then there's a $50 reduction if there's $50 on the gift card. But if they pay for your food directly, if they actually take you to the grocery store and buy food for you, or if they pay for your rent or other housing expenses directly, there's a different treatment of those kind of expenditures. They are not dollar for dollar reductions of your SSI benefit. There's a maximum reduction for that kind of payment, and that kind of payment is called in-kind support and maintenance. It's limited to food and housing costs, and if somebody pays for them directly, you get a reduction of your SSI of up to 1/3 of the maximum federal benefit rate. So you have a $245 reduction in your $735, which is the number for 2017 SSI check. So in explaining the POMS provisions on the ABLE account, they're going to key to in-kind support and maintenance, but they're first going to make a really large blanket statement. They're going to instruct the eligibility worker, do not count ABLE account distributions as income, period, ever. Doesn't matter what kind of distributions they are. If the beneficiary takes money out of their ABLE account, puts it in their pocket, goes to the casino and wastes it, gives it to their mother, does anything else, it's not income, because conceptually it was their money. And that's why I say it's so important that the IRS interpretation is that the account belongs to the beneficiary. Social Security goes along with that and says, when you take money out of your ABLE Act account, nobody has given you income. You've just turned your asset, your non-countable asset, into a potentially countable asset. But it even gets better. They say, you can take the money out and put it in your own bank account and then use it to pay for qualified disability expenses. And if it's sitting in your bank account on the 1st of the next month, generally speaking, if you intend to use it for qualified disability expenses, it's not a resource. So I have an ABLE Act account that has $14,000 in it. I want to pay my rent. I take the $1,000 out of my ABLE Act account and put it in my checking account, and it's not income when it comes out of the ABLE Act account, and it's sitting in my checking account. It's not a resource, except it is. That's the one case where an ABLE Act account is oddly treated. If it's still in my account on the 1st of next month, it's a resource because I intended to use it for housing. But if the reason I had withdrawn the $1,000 was to buy a Nintendo, or to pay for my food, or to pay my college tuition, or anything else, and it's still in my account on the 1st of the next month, it's not a resource. So I can take it out of my ABLE Act account so long as I intend to use it for qualified disability expenses other than rent with impunity. It'll have zero effect on my SSI. And that's a really profound development. If I intend to use it for housing, the only effect it will have is if I don't get my bill paid before the first of the month, I'm going to be over resources for next month, assuming that I have other resources, assuming my account is close to the $2,000 figure. Of course, if my account is $500 and I take out $500 to pay my rent, put it in my checking account, and don't get the rent paid until the 5th of the month, no problem, because on the first of the month I only had $1,000, and that was below the $2,000 limit. By the way, these rules sound a little bit mind-bendingly complicated, and they are, and it's another illustration of how foolish it is to make rules that are extremely complicated for people who are barely able to get by on the income and often have psychiatric or mental conditions that make it hard to understand. That it's exactly the worst population to have these arcane, peculiar rules for, but that's not different from the way we have operated these programs for years. And I'm sorry that that's true, and I'm sorry that it's, again, more complicated, but the complication provides some opportunity for some planning for folks who are otherwise unable to pay some of the necessities of life. I just need to mention what housing expenses are under the ISM rules. So again, we don't really care about this list for the ABLE Act account, except that if the reason the money is in your account on the first of the month is that you took it out of your ABLE account to pay for these things, then it will be counted as a resource. That's the only significance of this list in the context of ABLE accounts. These are the things that if your mother pays them for you, you will have a reduction in your SSI payment. Or if they're somehow provided otherwise, you live with your parents, it's the fact that you don't pay separately for these things that causes a reduction of your SSI payment. But in the ABLE Act context, again, the only significance is if you took the money out for one of the things on this list and it's still in your account on the first of next month, it's going to be counted as an available resource. And that list of housing-related expenses includes your mortgage, your real property taxes, your rent, heating, fuel, gas, electricity, water, sewer, garbage removal, insurance, homeowners insurance, if it's required by the mortgage company. The logic of that is homeowners insurance isn't a housing expense itself, but if it's required by the mortgage company, then it's part of your mortgage. Homeowners association dues will be housing to the extent that they include payment for sewer and garbage removal and water. Sometimes homeowners associations pick up those things. So those are the ISM housing items. Those are the things that cause you trouble with your ABLE account if the money is taken out of the ABLE account and is still sitting in your non-ABLE account on the first of the month. So again, distributions from an ABLE account are not income. Distributions for qualified disability expenses, not income. Distributions for food and shelter, not income. Distribution for gifts, distribution for anything, not income. Nothing that ever comes out of the ABLE Act account is income to the beneficiary. If the beneficiary takes money out of their ABLE account and leaves it in their bank account and doesn't intend to use it for qualified disability expenses, then they might be an available resource on the first of the next month. If they intend to use them for qualified disability expenses that include shelter items, then they will be an available resource on the first of next month. If they take the money out and they give it away as a gift, that might cause a penalty. It might cause you to lose your SSI because you made a transfer of assets, but it's not income. The income rules won't be implicated by any withdrawal from an ABLE account, whether it's a qualified disability expense or not. Of course, a distribution from the ABLE account that is not used for qualified disability expenses might have tax issues that I'll talk about in just a moment,
But let's look at some of the tax concepts generally. Contributions from third parties into an ABLE account are not subject to gift taxes. That's not quite a correct statement. If I make a $14,000 contribution to your ABLE Act account, that's not a taxable gift because it's less than the $14,000 that I'm permitted to give to one individual. And the federal tax law has explicitly said that a contribution into an ABLE Act account is treated as a completed taxable transfer and is less than the $14,000. But if I give you $20,000 of other resources and I put $14,000 into your ABLE Act account, now I have a gift tax consequence because the total amount that I've given you in this year is more than the $14,000 that is free. Assuming that you're not also making other gifts, there's no gift tax consequence from the contribution into an ABLE Act account. There's no income tax consequence for the earnings in the ABLE account. If you look at the Ohio and the Nebraska account structure, you'll see that one of your choices is to invest in fairly aggressive investment items. If they do well and those accounts earn income, not taxable while it's sitting in the ABLE Act account. When it comes out of the ABLE Act account, that's not taxable income either, provided that the expenditures out of the account are for qualified disability expenditures. And there's a list in the law of what qualified disability expenditures can include, and it's a pretty comprehensive list. It includes housing and education and travel and therapy and medical care. It is about as extensive as you could come up with if you sat down and wanted to make a list. And on top of that, it says, or any other item that the Commissioner of the Internal Revenue Service decides will be a qualified disability expense. So that list is only going to expand, it's not going to contract. And it's already a pretty expansive list. If that's what the money comes out for, then there's no income tax consequence. And remember, because the account belongs to the ABLE Act recipient or beneficiary, if they take the money out of the ABLE Act account and put it in their own account, waiting to spend it on the new car or the furniture or whatever big expenditure it is, that's still a qualified disability expenditure, even though it wasn't made directly from the ABLE account. In fact, if they go out and buy a new car or furniture or something, somehow, I don't know how they're going to do that with the $2,000 that they have of available resources, but if they do go buy a $2,000 car and then withdraw money from the ABLE Act account to replenish the $2,000 to pay themselves back for making that qualified disability expenditure, that is still a qualified disability expenditure when it comes out of the ABLE Act account. That has no tax or public benefits consequence, even though they're just reimbursing themselves. In theory, if an SSI beneficiary has a debit card that they use to pay for even food and shelter, well, food is a little harder call. They pay for shelter or education, entertainment, travel, anything that is a qualified disability expenditure. And then they take money out of their ABLE Act account and refill the debit card. That's an okay transaction. It has no tax or public benefits effects whatsoever. If you take money out of the ABLE account for a non-qualified disability expenditure, and I said food is actually a little bit of a problem because it's not on the express list. So if you take it out to pay for food or for gifts or some other problem, that won't have any Social Security effect, except that gifts may create a period of ineligibility, but it will have a tax effect. You will have taxable income as it comes out, that portion of the distribution that represents growth in the account. So you put $10,000 in, it earns $1,000. Now something like 10% of the money is taxable income if you take it out for non-qualified disability expenditures. And on top of that, there's a penalty for taking it out for non-QDE kinds of things. It's a 10% penalty.
And Robert, this is Elizabeth. I'm just wondering if you can talk a little bit about who is going to be evaluating the expenditures.
So that's another really good area to talk about. In the first round of Internal Revenue Service regulations, the states had to have systems in place to double check everybody's use of the money to make sure that qualified disability expenditure requirements were met. And the states all were horrified. You're going to drive up the cost of this program. You're going to make it unattractive for people. Nobody's going to sign up for it. It's going to be impossible to administer. And the IRS backed off and said, yeah, you know what, we'll just deal with it through tax filings. So there's not really anybody actively monitoring the accounts. There are safeguards in place at each of the state programs to try to keep people from using the money for non-qualified disability expenditures, at least without realizing they're doing it. But there's no active monitoring of the accounts provided for in any of the regulations at either the IRS or at Social Security or, for that matter, at the state programs at this point. That might change, and I think it might well change, but that's what we have set up now. So some things that come to mind after you think about this a little bit. Well, okay, you've persuaded me I need to go open an Ohio ABLE Act account. If I do that, will I, and then when Arizona finally comes online and has its own ABLE Act account, will I be able to move to the Arizona ABLE account? The answer is yes, though it's an odd, complicated way to get to that answer. What they say, hang on, what they say, just hang on one second while I think about what I'm doing here. There we go, no, I'm trying to get a window that doesn't block the slide, there we go. What they say is that although there's a rule that you can only have one ABLE account, that's a flat rule, no question about it. Never have more than one ABLE account. Oh, except when you're transferring from one ABLE program to another, you can have an empty ABLE account at the new program or with a nominal $50 contribution. And you can still have your old ABLE account until the transfer is effected. But there is specifically a mechanism to allow you to move from one ABLE account to another. In the meantime, the rule is hard and fast. You can only have one ABLE account per person. If somebody else opens an ABLE account, you have an ABLE account already, and your mother or one of the short list of people who can open an account opens another account in your name, the system is supposed to catch that there are now two ABLE accounts. In the meantime, and they're supposed to close the second one, but in the meantime, the second one is not a qualified ABLE account. So you have to be kind of vigilant. Families, we occasionally see this in special needs trusts where divorced families fight about who's going to be in charge of the management of the special needs trust for the joint child who has a disability, and maybe we're going to end up with two separate special needs trusts. That can't happen in the ABLE account world. There should only be one ABLE account for a person. Here's an issue that's really kind of an interesting one. There's a specific provision in the law, excuse me, that allows the beneficiary of an ABLE account to transfer the contents of their ABLE account to another family member with a disability. So my brother is on SSI, I'm on SSD. We both got our respective programs before age 26. I have an account that's built up to $25,000. I want to transfer some or all of that to my brother. I can do that without having to be limited to the $14,000, without having any gift tax consequences. One of the things that intrigues me, and I don't know how this is going to play out, but if I realize that I'm probably not doing very well, I'm going to die sometime soon, in order to avoid the payback requirement, can I just transfer my entire ABLE account to my brother who has a disability? I think the answer to that question is yes. We'll see how it plays out, but in the meantime, it's clear that an ABLE account beneficiary does have the power to move the account to another family member with a disability. It can't just be any random person. It has to be a family member.
One of the mechanical problems about opening an ABLE account is that it can only be done by the beneficiary, him or herself, or a parent, or a guardian, or an agent under a power of attorney. That's the whole list. If I'm the trustee of a special needs trust for a beneficiary who has a disability and I want to open an ABLE Act account, I can't do it. I can put money in the ABLE Act account. I can contribute to it, but I can't open or manage the account. That's got to be done by the beneficiary himself or his mother or his guardian, or he's got to sign a power of attorney to give somebody the authority to manage the account. Notice that they say guardian, not conservator. This happens from time to time with pronouncements that come from Washington where they don't use conservator of the estate in the way that we do in Arizona and in many of the more modern and western states. They are stuck in East Coast old-fashioned language. They don't distinguish between guardian of the person and guardian of the estate, but you have to have been appointed guardian in order to open or manage an ABLE Act account. So for people who have both a guardian and a conservator in Arizona, who are different people, they're going to have the odd circumstance that the guardian can open and manage the ABLE account, but the conservator will be the one who puts money in the account. And that's going to cause some small problems as we move along, trying to figure out how to manage accounts for people who can't manage their own accounts. There's nothing that prohibits the ABLE account from satisfying Arizona's dignity account requirement. So you've probably realized that Arizona's conservatorship law says a conservator should be quick to put money in a separate account that can be managed by the person who has the conservator appointed, so that they have personal autonomy and dignity. And the ABLE account is going to be a very attractive way to do that for a beneficiary who actually has the power, the ability to manage the account. They may not manage it perfectly, but they don't have to manage it perfectly. They can get the satisfaction and the autonomy from managing it at whatever level of capacity they have, and the conservator will be able to encourage that kind of an arrangement. So what about Arizona? What's specific to Arizona? Nothing about what I've told you is Arizona specific. Arizona has passed an ABLE Act enabling law, which is kind of a tongue twister. But all it does is so far is to create an ABLE Act Oversight Committee. It's a 7-member committee that's instructed to file a report by December the 31st of 2017 and to recommend to the legislature and to the Department of Economic Security what an Arizona ABLE account program ought to look like. So that committee is supposed to analyze the choices, consider some of the possible vendors. You know, are we going to use Bank of America or T. Rowe Price or somebody else to manage the Arizona ABLE account? Are we going to use the consortium program? Are we going to just rebrand Ohio's program? Are we going to start from the ground up and have it run by the state treasurer, as is going on in at least one state? I think Tennessee is the one that uses their state treasurer to manage the money. That committee is supposed to address all those things and report by the end of 2017. Assuming that it stays on schedule and does file its report shortly before December the 31st of 17, that would mean that the 2018 Arizona legislature would have the proposed ABLE program on its agenda and probably would consider it and adopt something sometime in the legislative session of 2018. And if history is any guide, that means that the law will be effective in September or thereabouts of 2018. Contracts would need to be let and the program actually, the website and everything put together. So it's reasonable to guess that Arizona will not have an active ABLE account program before late 2018, and pretty likely early 2019 is the earliest we're going to see an Arizona ABLE program. So if you're thinking, I'll just wait until Arizona's program is in place, well, you got a reasonably long wait. You're going to be 2, maybe 3 years before you can open an Arizona ABLE Act account. that committee, a week ago when I was preparing this PowerPoint, I would have said we don't even know who's on that committee, except we do know the director of the Department of Economic Security and the state treasurer, but the other 5 members are someone with a financial background, an attorney, a person with disabilities, a family member of a person with disabilities, and a community organization representative, an entity that works with people with disabilities. We don't even know who those 5 people are, much less where they're going or when their meeting schedule is going to take place. Well, I do know who one of those people is. I'm not entirely sure that I'm supposed to say, but last week I learned who the attorney member of the ABLE Act Oversight Committee is. I worked pretty hard at trying to find out who the other members were yesterday so that I could break the news to you. Anybody who asks me off list about the attorney member, I'm happy to tell you, and you can probably figure out how it is I know. So when are you going to set up an ABLE Act account? That's the real question. Is it time? So here are the people that I think, this is my thinking, and I think Elizabeth is probably going to agree. We've talked through this. She may have some other ideas. These are the people for whom an ABLE Act account makes really, really good sense. First one is there's a significant category of people who are receiving SSI who are unable to pay their rent and get some subsidy from their parents, and it might be room and board, not just rent, it might be room and food. And because they get some subsidy from their parents or some other source, but it's often parents, their SSI is reduced. So let's take a 25-year-old man who is living in the community in an assisted living setting where the rent is, let's say $1,500 a month, the rent and the cost of all of his care. And he only gets $735 of SSI, and so his parents have been paying the difference. Well, because somebody is paying for his room and board, that actually reduces his SSI. So instead of getting $735, and by the way, that's, I think I mentioned before, that's the 2017 number. I like using the 2017 number because it's divisible by 3, and that's important for ISM calculations. So because he's getting support from his parents, he's getting a reduction of $245 in his SSI. And that means that the parents have to contribute an extra $245 in order to cover his room and board. Well, under the ABLE account, they could open up an ABLE account for him. Even if he is unable to manage it himself, parents can open up the account. And so they can open up the ABLE account, or he can. They can put $1,000 a month into the ABLE account. That'll stay under the $14,000 a year. And now he can use that $1,000 a month to pay his rent. His SSI will go back up to $1,735, and that basically means he's got some spending money as well as barely making the room and board. Now, obviously, the circumstances will be different in every case, and these numbers may not work in individual cases, but you can see that there's a class of folks for whom you can improve the quality of their living arrangement and their access to a little bit of additional spending money just by institutionalizing what's already happening with family member contributions to pay for their room and board. I think the next category of people that really will benefit from ABLE Act accounts is people who just really would benefit from increased autonomy. It's very frustrating for a lot of people on SSI particularly. People on SSD don't have this problem, but people on SSI can never save more than $2,000. And many of them are very attuned to being careful and spending their money slowly and setting aside a little money and managing it. And yet they're told once every couple of months they have to spend all of their excess money that they've accumulated in order to stay below the $2,000 limit. And this will give those folks an opportunity to manage money, to make investment decisions. The Ohio program, for instance, gives you 5 different levels of investment types, everything from a basic checking account up to high-risk investments or relatively high-risk investments. So people who are interested in doing that can really improve their autonomy and their self-determination by being allowed to handle more than just little tiny $2,000 accounts that can grow over time. I think that one of the ways that we'll see in our office, we'll see ABLE Act accounts used a lot, is that for people who settle a small personal injury case of less than $14,000, right now their choices are to spend a couple $1,000 setting up a special needs trust, which is a silly result for a $14,000 personal injury settlement, or spending $500 and turning the money over to a pooled trust operator, $500 to $1,000. It's expensive and it's annoying to lose the control of the money. Instead, they'll be able to just put that money in an ABLE Act account, receive a benefit from the settlement of the small personal injury case. And, you know, this is December, so if today a $25,000 settlement came in our door asking how to deal with it, we might say, tell you what, let's open an ABLE Act account right now, put $14,000 in it, hold on to the other $11,000, lose SSI for 1 month, and then in January we'll put the balance into the ABLE Act account, and the only effect will be the cost of 1 month's SSI loss in order to settle an even somewhat larger personal injury case. I think we're going to see a lot of those small personal injury cases being resolved that way. We have a question. Can the funds from an SSI retroactive award and even accounts in a conservatorship be put into an ABLE account? There's nothing about the ABLE account that prevents them from going in there. Remembering, of course, there's the $14,000 limit. For retroactive awards from SSI, if it's less than $14,000, I don't think there should be any problem. I can't think of any reason why they can't go into an ABLE Act account. A conservatorship of $10,000 is a little bit more challenging because you're asking the court to agree that the money can be turned over to the very people who have not been permitted to manage the money for good reasons. So you've got to convince the court that it makes sense to terminate the conservatorship, or perhaps not to terminate the conservatorship, but just to put some of the conservatorship money in the ABLE Act account. But I don't think that's too hard of a sell in most cases. If you say the advantage is that my protected person will have much more self-control, and they'll have, yeah, there's some risk that they'll waste the $10,000, but actually what's happened historically is they've hoarded money rather than spending it. I don't think you're going to have too much trouble selling that to a conservatorship judge, and I expect to be doing it. In fact, we have filed our first petition asking to do that already, to terminate a small conservatorship and put all the money in an ABLE Act account. Many of you probably have cases where they just keep going up over the asset limit. It seems impossible to believe that $735 a month would accumulate to the point where it's hard to get it below $2,000. But the problem with the $2,000 limit is you can't save for a seriously big investment like a new car or a down payment on a house or anything of moment. And now suddenly you're going to have an opportunity to shovel the excess resources into an ABLE account and allow it to grow a little bit more. And I think it's also an opportunity to avoid special needs trusts for the small inheritance when you, because you're such a nice person, in your will you say, I leave $10,000 to each of my nephews and nieces, and one of your nieces has a disability. She just got $10,000 that knocked her off of SSI, made her ineligible for Medicaid. Guess what? We can put that money in an ABLE Act account. We're going to need the court's approval to do it, but it's going to be a really good resolution for that kind of a problem. I've got a couple of questions that have come in. Do we know the committee members in Arizona on the ABLE account? As I already said, we know one. If that's not enough hints yet, then you're not paying any attention at all. And any other questions? Let's see, can the minors' dedicated funds required by Social Security on the age of majority be placed into ABLE without a conservatorship. So what I imagine that question is asking about is a UTMA account. So let's guess that there's that mom and dad set up a UTMA account for Junior when he was 5, and they put $10,000 in it, and it's grown a little bit. There's now $12,000, and Junior is about to turn 21. When he turns 21, that's going to be an available resource for SSI purposes, and it's going to knock him off of SSI. Could that money be moved to an ABLE Act account? Absolutely. I would do that in a heartbeat. And so if anybody has any trouble with that, feel free to talk to us, because we would think that would be a good resolution. Now, if that account's $100,000, we got a different problem, because we can only put $14,000 a year into the ABLE Act account. But we could put $14,000 in, try to figure out what to do about the other 86, and over the years keep contributing to the ABLE Act account as a way of minimizing the problem. What if a parent establishes an ABLE Act account for a beneficiary that lacks capacity and the parents die? Now what? When you sign up with the Ohio account, it asks if you want to pick a successor custodian of the account. But this is a really good question. It indicates the ways in which some of this was not well thought out in advance. In theory, only a parent can manage it. So if you name me as your successor, and I'm not asking for this job, I'm just saying random person who isn't related, it's not clear that I have the authority to manage the account. We're going to have to see how those questions sort out over a period of time in order to figure out exactly how they work. Let's see, I think I've answered all the questions online. I'm pointing you to our office newsletter. It's a weekly newsletter. We talk about ABLE Act accounts, guardianship, conservatorship, estate planning, all sorts of issues involving the elderly and the disabled, and we're pretty proud of it. We have written about the ABLE Act several times, and there's a lot of information about the ABLE Act on our newsletter, on our website where the newsletters are archived. You can also sign up for the weekly newsletter if you want to. We're happy to have new subscribers, and there are other resources available. We've given you the link to the SSI POMS sections on the ABLE Act as well. Oh, what a good question. This question comes from a public fiduciary. Is there any way that a public fiduciary guardian can find out if there is an existing ABLE account? You know, that's one of the reasons I wanted to do this webinar, is because I was sure there are questions I hadn't even thought of, and that's a new one for me. I haven't thought about it. For the moment, at least, you only have to call or write to 4 entities, because there are only 4 places where an ABLE account could be. But over time, it's going to be more and more likely that there will be accounts out there that are hard to track down, and so that's going to create a new headache for guardians and conservators trying to locate resources. Yeah, sure enough, that's going to be an issue. One of the things that I really anticipate seeing is that special needs trusts are going to include provisions authorizing the trustee to set up, not to set up because they can't set up, to fund an ABLE Act account or to give money to the beneficiary to go into the ABLE Act account. And I think that's going to be one of the ways that's one of the interplays that will work. I've already said I think conservators might be encouraged to set up ABLE Act accounts. So there's going to be an interplay between special needs trusts, pooled special needs trusts, conservatorships, and ABLE Act accounts that's going to get more complicated over time. Are there any other questions that we can try to answer about the ABLE Act in Arizona? I'm going to give it a couple seconds pause to see if anybody throws in last-minute questions. What has been Alltech's response to these types of accounts so far? Alltech has not been heard from on this score. I will tell you that I anticipate that one of the things that the ABLE Act Oversight Committee is likely to do, I hope, cross my fingers, is to ask for a modification of the Arizona statute governing special needs trusts, self-settled special needs trusts, those things that 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 can be paid for out of a special needs trust that comes from the beneficiary's own money. I am hopeful that there will be an addition, specific addition, to allow the funding of an ABLE Act account. With the payback in place, it seems to me that Altex should have little trouble with transferring money from a special needs trust to an ABLE Act account, and that would be a great boon to the beneficiaries of special needs trusts, I think. Any other last-minute questions? Thank you all for participating, and as I say, if you would like a link to the recording as soon as it gets completed and posted, I will have that available. Let's look forward to what the next ABLE Act adventure chapter looks like in Arizona, and I'll try to keep you posted. Thanks, everybody, for participating.